Hi everyone, and welcome to another episode of IP in our IP series. I'm Anthony Alder from Alder IP. Today we're lucky enough to be joined with Paul Fitzgerald from Barking Dog Marketing. And Paul's here today to talk to us a little bit about his experiences with trademarking and to share some of the things that he's learnt with his business and that sort of thing.
Thanks, Anthony. It's a pleasure to be here. I have my brand name and logo trademark, Barking Dog Marketing, which not a lot of people do, unfortunately. They register a business name and they think that's enough. But I've recently had an issue where I've had an international company from the UK enter the Australian market and has actually infringed on my trademark. And obviously you've been involved and we've sent them some cease and desist letters. But because my brand name and logo and all of that sort of stuff is trademarked, we've been lucky enough to be in a position to actually take some action and try and protect that.
That's right. And basically, because it's been registered and gone through the whole registration process, we can actually take some proactive steps to stop it from happening in the future, which is to encourage them to desist from using it in the future and cease from using it right now. Also, there's other alternatives that can happen as well, and sometimes business owners are quite happy for the other company to coexist, but and sometimes it just depends on your business circumstances as to which way you want to go in a lot of these cases. But the thing is, the registration of the trademark actually gives you an exclusive right to stop other people from using it. So it means that you own a sort of a limited monopoly over the name, and the simple reason is because your brand name is your most important asset.
Anthony, what would have happened if my brand name and business name wasn't trademarked and it was just registered as a business name? What would have been the difference?
Okay, the difference is that there are two kinds of trademarks in Australia, at least. There's common law and registered trademarks. If you don't have a registered trademark, you have to rely on the common law. And the common law is like old English law that's existed for hundreds of years. Okay, it's not designed to deal with this kind of problem because they didn't have this problem hundreds of years ago. And under the old sort of English law, which is the common law, the approach was they sue you under a thing called passing off. And passing off is where you have to show that you have a reputation that's really strong with consumers and that they misrepresented you. So it's almost like an act of fraud in some regards. And that there's also been damage that's come along as well that you've suffered. Now, in Australia, there's numerous of companies that have tried to push people for common law trademarks. They sometimes do it successfully. But when you look at some of the companies that have failed to even show common law rights, Coca-Cola, McDonald's, there are significant hurdles here. And particularly if you're a small company or you're a startup company, you won't be able to show the reputation that you need to protect your brand. And that's why you need a registered trademark, because if you've got a registered trademark, the default setting is in your favor. It basically shows that I've got this name, I own it, and it's mine, right? I don't have to prove anything else. It's up to them to prove that they're not infringing. So it shifts the onus of proof onto them, which is clearly in your favor.
And I guess the other important thing is, Anthony, not a lot of people realise is trademarking is just one component. Then you've got to be seen to be protecting that trademark. Because if you don't protect that trademark, then what's the potential implications?
Yeah, if you do nothing to protect your trademark, that's really doing yourself a disservice. And you can do little things to protect your trademark. A good example of this is the word escalator. If you look at the word escalator, everyone knows what an escalator is. If you tell someone, "I'll go ride the escalator," they know what you're talking about. But it's not actually called an escalator. An escalator is the trademark term that was invented in the 1900s, 1930s for what's called an inclinator. Okay, and it became so common that it became genericized, which means that it basically lost the ability. It just became generic and lost the ability to be trademarked or had any kind of trademark protection. And usually the test for that and the gut feel test for it is if it ends up in a dictionary. If it ends up in Australia in the Macquarie Dictionary or in an Oxford Dictionary, you got problems, and you can't backpedal from that, right? So what we usually encourage people to do is use their trademark as a trademark. And you can do simple things to make sure it's used as a trademark. The most simple thing is if it's registered, you put a little R in a circle. If it's not registered yet, you put a TM after it. That's fine too. In fact, the TM is probably a safer bet anyway, because you don't have to change it when it does get registered. You can just keep using the TM. And also don't so much use it as a noun. Marketers like to use a thing as a noun to sort of describe what it actually is. And there was a one recently with, or in the last 5 or so years, that was Kleenex tissues, right? And they were on the way to becoming genericided, because people would say, "Oh, it passes Kleenex," and people would understand what that meant, right? And it didn't actually mean passes a tissue; it meant passes a Kleenex tissue, and they should have been calling it Kleenex tissue. And what they've been doing is they've been gradually adjusting their marketing so that it does actually say Kleenex tissue on the box and that sort of thing. So if people do call it that, they're happy for that. That's fine. Great for marketing. Not so great for the legal perspective of enforcing your rights. So so they juggle these things.
It's really interesting, isn't it? I worked for a brand years ago called Thermos, and over in the US, everyone knows Thermos is the vacuum sealed flasks.
Yep.
Where Thermos is a brand name and it's not actually the product. But people say, "Have you got a thermos?" And it means a vacuum insulated flask which keeps items hot or cold. Yes, Esky and other bits and pieces.
Yeah, there's a lot of brands like that. Esky is another one. In Australia, Esky is just an insulated carrying device. Or in New Zealand, Chili Bin. Chili Bin in New Zealand is the brand name that was the first one that was out there, and so everyone calls it Chili Bins.
And I think the important thing for people to understand is it's not super expensive. It's not super complicated. If you go to professionals like Alder IP, you go to a firm that specialises in intellectual property, and the benefits far outweigh any sort of initial costs.
Well, that's the whole thing. Even if you did it yourself, the chances of you stuffing it up are about 90%, right? Because it's very technical. You wouldn't do a conveyance of your house. You wouldn't do these sort of things by yourself. You would go to a legal advisor. Trademarks are the same. Just because it looks simple on a website, don't try it. Otherwise you'll just end up wasting your money. You'll come back to us and we'll have to fix it. And doing it properly in the first place is much better. And it doesn't cost that much. The other thing is it's the cheapest insurance policy you've got for your brand, because the thing is, when you do get a registered trademark, it does have the extra bonus that no one can sue you for using that trademark once you've got it registered. So it means you're immune to prosecution, and it means no one can come out of the woodwork and say, "Hey, that's my brand name. That's my name. Stop using it," because you've got it registered. You got there first. And we find a lot of the value in a trademark is the preventative measure, not even the punitive side of it. So you've got the sword and the shield type approach to these things.
And I think the lesson is, it doesn't matter how small or how big your business is, having registered a trademark is, priceless.
That's right. And the thing is, it also, a registered trademark sort of levels the playing field between big companies and small companies, for exactly the reasons I said before. Like a common law trademark, you've got it's completely imbalanced. For a startup company, you can't show reputation because you don't have any reputation to show, right? And even but the thing is, if you register that right, you're basically staking it with the government to say, "I invented that name on that day. I started using it on that day. That's mine," right? And that whole process, it develops something that's actual an asset for your business. It also means that if you ever sell your business or ever want to exit your business for any particular reason, you've actually got an asset there to sell. If you haven't done that, if you haven't gone through that basic registration process, then really, what are you selling at the end of the day? Like, what is your brand? You haven't done anything to protect it. You haven't, and so you've really got to ask yourself, well, if I'm serious about my business, I'm serious about getting a trademark and protecting my brand.
Yeah, absolutely. Now, Anthony, I'm a big fan of the IP series, and obviously I help you produce the series as well. But how did you get into, obviously you're a lawyer, a solicitor, how did you get into the niche of IP? And it's obviously a really important area of law, but I'm keen to explore that a little bit. How you found yourself in this sort of space?
Well, I've always been interested in inventions. I started off when I was a little kid. I walked around my grandparents' house and ripped out all the PowerPoints with a bread knife because I wanted to see how they worked, right? And this is a problem with patent attorneys. I think we are compulsively puller aparters, if that makes sense. We just pull things apart just to see how they work, and that's why I like my job. Because it's kind of a fun job. I get to deal with all the new inventions and all the new trademarks and all the new brands that are coming out. So I get to see them all before everyone else does. But also I get to work on a lot of fantastic projects. Like we work on everything from kids' toys right up to high-end medical devices.
So were you potentially heading down that path of being an inventor? Have you invented anything yourself?
When I was at uni, I worked with one of my best friends, and we developed a blinker system for cars and that sort of thing for disabled people. And that got us through uni. And the kind of funny thing about that was the fact that it became so big that we couldn't actually we were manufacturing it ourselves in our garage. We couldn't manufacture it anymore because we were getting too many orders, so we had to sell it.
Well, that's a great story. And then, so that was why you're at uni studying law.
Yeah.
And then you sort of followed that passion once you graduated.
Yeah. So I started. I actually graduated from science originally, and I worked in as a biochemist virologist. I always wanted to do law, and I got a job in a law firm, being a technical assistant. And from there, I didn't even know about the patent attorney profession because it's so small. And so basically they took me under their wing and taught me a whole lot of stuff. So and that's where I started. Yeah.
Yeah, got it. So you're an inventor. You invented something, studied science, graduated, found yourself in a law firm as a technical assistant. Then you discovered this passion for basically IP, because you know, protecting your invention is probably the most important thing aside from inventing whatever it is.
Yeah. Yeah. So, and also helping other people like along the invention pathway. Because I'm a little bit different. I worked, not only did I work in a law firm, but I've also worked in-house. And I've had a lot of in-house experience with inventions. And that's kind of a completely different experience, because you're actually raising money for the client internally. And so you actually have to go to road shows and speak about their product and talk about why people should invest in their product and that sort of thing. And answer like really probing questions, particularly with medical devices and pharmaceuticals. So, yeah.
I've had an insight into some of the bits and pieces that you've been lucky enough to work on, but is there, one or two things in particular that really stand out where you're like, well, this is incredible?
The best one I've ever worked on is a product called the Venture Assist, which was an artificial heart. And believe it or not, it's a replacement for a person's heart, and it works. It's a special pump, and it's implanted within a person to replace the function of their heart whilst keeping their heart there. And the way it works is it produces a continuous flow. So it's a pump that produces a continuous flow. But the really nifty thing about it was, if you know anything about pumps, all the centrifugal pumps have a spindle in the middle that spins around it. They got rid of the spindle, and they got rid of the spindle by making the little wings or the fins of the pump like aircraft wings. So they actually produce thrust, and they actually produce thrust and lift. And so when you're producing lift, they're producing lift in both directions, which means it levitates. And the faster it goes, the more it levitates and the more stable it becomes. And it actually, you've got this pump that doesn't actually have any points of stagnation in a pump. And they actually implanted this in over 250 people. And there were people walking around with this artificial heart pump. That's one of the most mind-blowing things I've ever worked on.
Pretty incredible.
Yeah. Especially, I got the privilege of actually meeting some of the patients that were implanted, yeah, and seeing, because like a lot of these people that were implanted were ineligible for heart. They needed basically they needed a donation heart, and there's only 2,000 of those worldwide available, and there's 60,000 people on the waiting list. And this, this was an alternative to that. And I remember seeing one guy, and he was the first guy that was implanted, and he had 2 weeks to live, and they implanted him, and he lived for another 3 years. And when he did die, he didn't die of a heart condition; he actually died of a stroke, of other causes. So yeah, it's kind of an amazing story, that, and yeah, the product was called Venture Assist. So,
yeah, wow. Well, that is super incredible. The fact that you're working on something that's saving lives,
yeah,
revolutionary product. You've met one of the recipients, and it saved his life.
Yeah.
Pretty incredible.
Yeah, but they're not alone. Like, we get lots of products like that, and I've worked on everything from the cochlear bionic ear to like kids' toys, right down to surfboards, kids' toys. And the thing is, none of the important thing to note about particularly the invention cycle is patents are one step in that process, or protecting your IP is one step in that process. But it's not the only step, and you have to get a whole lot of other things right too. And there is a whole lot of work in getting a product out to market. And it's
just on that, what sort of advice would you give a young inventor, an old inventor? What advice would you give these people?
I think it boils down to Edison's quote about inventions being mostly perspiration and tears. I think it's more than anything else. Just working hard at it. And like, if you don't know something, ask. Find someone who does know about it and ask them. Right? We know all about the legal side of it, and we're quite happy to help anybody out with the legal side of it. And we can help people out with corporate commercial contracts, as well as doing the patents. But there's more to it than that. There's also, development, product development, research. There's whether it's manufacturable at the end of the day, whether you can actually produce it at the price that you need to be able to do it, and whether you can sell it and get it to customers. Getting it to customers is sometimes the hardest thing.
Well, one thing you've mentioned to me before is that because you've seen so many inventions, and because you're so well versed in that sort of patent area, that you're able to give your clients honest and transparent advice. And sometimes that advice is, look, you're pushing shit uphill here,
Yeah. So, sometimes, look, we're brutally honest. If we think your invention is going to have problems, we're going to tell you, right? Sometimes it actually, in fact, the invention comes out better because of that discussion that we had. Because sometimes the inventor comes back and goes, no, they will do it wrong. We do it this way, and we've got this improvement, and that's really what we want, because it gives us a story. So then, when the patent examiner raises that with us, we've got some ammunition to go after him with, right? We don't just have to sit back and just expect it all to be granted, and also being forewarned is forearmed about these sort of things. Also, if you do find something that is a knockout for trademarks or for patents, you're better off to take action early. Proactive prevention of these sort of things is much better than cure. Particularly with trademarks, if you find a conflicting trademark and you're only 2 weeks into developing your product, dump the name. Why keep it? You're just creating heartache for yourself. Dump it, get a new name. Probably cost you a couple $100 to refile it. Compared to federal court costs, which could cost you $200,000. It's pretty much a no-brainer. Learning about these things early on is really critical, and getting some honest advice, I think, is critical too.
Yeah, look, I agree, absolutely. So tell me a little bit more about Alder IP. Obviously, your specialist IP firm. Yep. How long you've been around for? How many lawyers you have on staff, etc.
Yeah, we've been Alder IP was started by me. It was started 7 years ago. It was started, and we've grown. We're every year we put on extra staff, and we keep growing. And I think part of that success has been attributed just to our honest approach. Okay, we're not going to basically, if you come in with an invention and we see a problem with it, we're not going to sugarcoat it. We're going to tell you straight up front there's a problem, and we're going to work with you to try and get a solution. Now, we don't just give you problems, because that doesn't help anyone at the end of the day. We try and work with you to get a solution. And I think that's why we're a little bit different to a lot of the law firms you talk to. They sometimes just go, here's the problem, and dump it on your lap, and then go, you work it out. But we try and give you a solution. I'm a really big proponent of trying to give people a solution rather than just give them problems. People don't want to hear problems. Problems are everywhere. So we try and give you the solution as well as the problem. And that's what we try and work through. But look, I've got a really experienced team, and they're a great bunch to work with. We've got experience. The team has got a vast range of experience. We've got everything from biotech to electrical to software to materials scientists to civil engineering. We can cover it. Okay, so and they're kind of an interesting group of people to talk to.
Yeah, absolutely. Look, I obviously I'm a client of yours, and I help you produce the IP series. But my dealings with the team has been fantastic. Super professional, super helpful. Nothing's an issue, and very easy. So,
thanks, Paul.
Yeah, I think it's been great. Well, Anthony, that's I'll sort of turn the tables. You're going to ask me a few questions, but I was really keen to sort of dive into your background and Alder IP and the sorts of things that you've worked on. But I think it's a really interesting space, the IP space. I think it's super important. Obviously, definitely from my perspective, from trademarking and protecting your business and brand names, and then right through to inventors and inventions and patents and having that commercial capability. Then also, I guess the next most important thing with this invention is taking it to market and then marketing it and all those sorts of things. And that's an area where your firm, Alder IP, can really advise people on right through from inception through to taking it to market.
Yeah, right through to commercialization. So we can help you out with the contracts and that sort of thing. But the main thing is, particularly with these, if you come up with an invention, talk to us early. I think that's really critical to making this a success. Is if we can file your patent or file your trademark really early in the piece, it really helps your case, because the longer you leave it, the more problematic it becomes. Particularly if you people. We've had clients before that have accidentally disclosed their invention on things like YouTube or Instagram or Facebook. And it's very difficult to put the cat back in the bag once it's escaped, right? So it's much easier if you talk to us straight up and really early on, and we'll help you out.
Perfect. Well, thanks, Anthony.
Thanks, Paul.
Been a fantastic chat, and we'll catch up soon.
Thanks, Paul. Appreciate it.